All right, you filed your H petition or your L petition in immigration to start the process to get an H visa or an L visa. The Immigration Service Center sends back an RFE, a request for additional evidence. Problem? Not necessarily. It's not the end of the world. It just means they may want more information or want to clarify some information. So you have a deadline to respond. Typical examples is the occupation being offered, a specialty occupation. Or if it's an L1B, is it really specialized knowledge? Give us some more information about specialized knowledge. Request for evidence. We try to avoid those. I've kept a list of requests for evidence over the years, and even though it's not required evidence, I still file it up front to avoid an RFE later on, because RFEs can be time-consuming and costly and delay your project, so we try and avoid them by preempting an RFE, supplying the information we might expect ahead of time. All right, so let's say you get your petition approved. Next step, you visit the American consul. You do a DS-160 form electronically. You pay your fees. Now you have an appointment to go in and see the consul. Processing times to get appointments and get results at consuls vary from consul to consul. Check the website, U.S. government, State Department website for processing times. They'll give you some idea of what the turnaround time is. There's an interview waiver program for citizens of India and a few other countries, but it's only for renewals, extensions of B1, B2s, H's or L's, and student and J visas, F and J visas. For L's, it does not apply to blanket visas. So, two terms you're going to hear, well, hopefully you don't hear, but we often hear from consuls are Section 214B of the Immigration and Nationality Act and Section 221G. 214B involves strict non-immigrant intent for B1s, B2s, F1 student visas. Must have strict non-immigrant intent. If you say or do anything that indicates you're going to stay in the United States long-term permanently, they will deny the visa. You have to prove that, well, there's a presumption in the law that you are, when you apply for a temporary visa, you're planning on coming and staying permanently in the United States, and you're required to overcome that presumption with additional evidence. 214B. We'll talk more about that at the mock consular interview. 221G, different refusal. They need more documentation, for example, so they put the case on hold until they get it from you. Typical example, IT consultants. Remember who's the employer? The client or the consulting company. They may want to see all those contracts and vendor contracts and all that stuff before they make a decision. They may send the petition back to the Immigration Service Center for study and possible revocation. 221Gs, they call it administrative processing. That doesn't tell you anything other than your case is going to be delayed for a while. For consultants, it's usually to determine who the employer is. Most important thing I can advise people before they go into a visa interview with a consul is be prepared. The worst case scenario is the employer gets the petition approved, sends the approval notice to the employee, makes an appointment, employee goes in for the visa, but employee is never given a copy of the petition paperwork, doesn't know what the job's all about, what the pay is, where he or she's going to be working, what they're going to be doing, and the consul is going to pick up on that very, very quickly and deny the visa. So prepare your employees before you send them into consuls. If a consul denies a visa, if it's 214B, non-immigrant intent, can try again with better, stronger evidence. If it's a legal issue, may be able to get an advisory opinion from the State Department, but that takes time. B1 should have a letter from the company, the employer in India, that is sending them to the United States on a business trip. That letter should cover information about the company, information about the employee, information about why that employee has been chosen to come to the United States, specifically what the person is going to be doing in the U.S., hopefully meetings, and the duration of stay and why you need that duration, and the fact they're going to come back to India and implement the information or whatever they got in the United States at the employer in India. That's what should be in the letter. As a practical matter, when I was a young attorney many years ago, I went to a seminar and an older attorney said, keep your letters to government, to bureaucrats at one page. If they have to turn the page, they lose interest. So try to fit it all in one page. I know it's a crazy idea, but it works. Drafting job descriptions. Remember, H-1Bs have to prove it's a specialty occupation. Detailed technical job descriptions, very, very important. Remember, L1s have to be managerial, executive, or specialized knowledge. Detailed job description, organizational charts, very, very important. When I trained paralegals who worked for me over the years, attention to detail is critical for success. Lack of attention to detail is what loses cases or delays cases. Premium processing. There is an expedite procedure for the first part of a petition-based case, L's and H's, where you file a petition with USCIS. It's called premium processing for an additional $1,225 filing fee. The government will guarantee a response to the petition. Notice I didn't say approval. Response, either an approval hopefully, or request for evidence within 15 calendar days or less. Give you an idea why that might be helpful. Normal processing for an H1 petition right now is maybe 3 or 4 months. Normal processing for an L petition is maybe 2 or 3 months. If you can reduce 3 or 4 months or 2 or 3 months down to 15 days or less, it can be very helpful in getting your people over for your project, but it will cost you an additional $1,225. I don't believe in giving the government money unless I get something in return, and a filing fee of $1,225 is a lot of money for a filing fee. So if I have an urgent need, I'll use it, I'll recommend it. But if you don't have an urgent need, it is possible to file the case regular processing, but if the urgent need develops while the case is still pending, you can convert it by paying the fee and filing the form in the middle of the case. It'll immediately go to the top of the pile. Government processing times are online on the website, so plan ahead. Next point, social networking. Believe it or not, the immigration officers know how to use a computer and the internet. And they will oftentimes Google what's on the internet about your company or your employees. So make sure that the information you put in your petitions is consistent with what's on the internet. If it's not, you better clean up the internet. If a petition is denied, the first step in the process gets denied for whatever reason, even after an RFE, again, there are options. One is maybe an appeal, if there's an error in law, but not practical. Appeals take more than a year to get an answer, and 97% of appeals fail. So I don't want to wait more than a year just to find out I failed. So what you might want to try is maybe a motion to reopen or reconsider. Might shorten the time. If you have new evidence or a change in the law occurs, that's rare, but it does happen. Or, better yet, analyze the reason for the denial, find a way to address those issues, and maybe withdraw the case and refile it, addressing the issues again in a different way. Maybe much more effective. So, at this point, we're going to ask a few more questions and give out a few more prizes on miscellaneous visas, starting with, what is the appropriate visa for a group of 12 comedians wishing to come to the U.S. to tour? I know what I said, but there's another possible one. So, anyone have an idea? I mentioned it. A little creative thinking. Anybody? Everybody said P1 because that's what I got for the group. I mentioned the other visa. Tell me why. You almost raised your hand. I mentioned the other visa. No. Huh? No. Anybody? What about a P3 visa? What if the comedy was unique to a particular country? India in this case. Just a thought. I considered, because it was, in that case, arguably, but I used the P1 in that case because it was more straightforward. What's the appropriate visa for an electrical engineer with a PhD and several patents for his research who wants to come to the United States to work in a research laboratory? Appropriate visa. Okay. I heard EB1, I heard O1. Okay. EB1 is a quota category for a green card. It's not a type of visa. O1 is one of the answers. O1 is the obvious one. But what if another one's available? There's a clue there. What if another one's available? Wouldn't it be easier than all that documentation to prove extraordinary ability? What's the other one? Right here. H-1B. If the quota is still open, I go for an H-1B long before I'd ever file for an O-1. Much easier. All right. Can an EB-1 extraordinary ability scientist, does he need a job offer or a sponsor for a green card? Hands? Right there, BJ, right in front of you. No, he doesn't. Okay, you can self-petition, that's correct, but following up, and you get a prize, but I won't hold you to the answer. What does he need? If he doesn't need a job offer and can self-petition, what does he need? Well, he can have a job offer, sure. Doesn't need to self-petition, can have an employer petition. But generally, if he self-petitions, he just needs a plan, a business plan, how he's going to use his extraordinary ability in the United States, okay? Contracts may be a business plan. Okay, we have our individual named Raj, who has invested $750,000 to create a new business in the United States, and he employs 12 people in the U.S. Can he use this business to get an EB-5 green card? I hear yes. I heard some no's. Okay, let's raise hands. It's the same hands. Let's try you right here in the front. Here's the microphone.
If investment is in the distress zone or in the zone.
Again, you're the first city that we've come to where we got the right answer. Okay. If it's less than $1 million, but it's more than $500,000, it's created 10 jobs, certainly. But only if it's in a, remember it's his own business, not a regional center. As long as it's in an economically distressed area that's been determined, he can do it for less than $1 million, but more than $500,000. Lastly, Kumar has reached his 6-year limit on his H-1B as an engineer. Can he extend his H-1B beyond the 6-year limit? 3 ways. I need all 3. 3 ways to extend beyond H-1B beyond the 6-year limit in the very back. There are 3 ways. I need all 3. Wait.
One way is he has to sit and calculate the time that he spent outside the United States for any days or whatever the reason. Notice the document and we can get that time that he spent outside. We can extend the visa for another time.
Okay, that's one. It's called recapture time. There are 2 other ways. You don't have them? Okay. About right here. Oh, you have a prize already, don't you? Okay, no, you can't have 2 valuable prizes. They're too valuable. Anyone else? 2 other ways to extend his H-1B. Okay, over here. Wait, you have just one? Okay, one at a time.
Applying for visa before the end of the year.
Okay, applying for the green card before the end of the 5th year on his H-1B will get extensions of how long?
1 year. 1 year.
Okay, 1 year at a time. What's the third way to extend his H-1B? Right behind. You get increments of 3 years at a time. Okay. All right, so at this time, let me just make an announcement. You have question cards on your tables. Please fill them out if you have questions, submit them, and we will hopefully address them at the Q&A session later.